I have also found that they don't really follow the CFCSA, but know it and be prepared to argue it, because the CFCSA are guidelines and regulations that are meant to protect you and your children. They were written with the best interests of children in mind, and they need to be implemented, and they're not being implemented.
No, they make excuses for not implementing different areas, and in consequence, the children are suffering incredibly, and they're being damaged emotionally and physically through the long duration of the processes, the delays, and even their placements.
And the delays, that's another thing. 7 days after your children are apprehended, you are supposed to have a presentation hearing. 7 days. At that presentation hearing, the ministry provides a report to court to the judge stating why they apprehended your children. And you have no opportunity to defend yourself. You have no opportunity to state your side of what happened. At the presentation hearing, it should be set up that a protection hearing happens within 45 days. You are supposed to have a protection hearing 45 days after your children are apprehended. That very rarely happens. The ministry is allowed to ask for a case conference if the ministry and you do not agree on whether there should be a protection hearing or not. And very few parents agree with the ministry, because the ministry rarely ever wants to have a protection hearing. They want a case conference so that you will sign that consent and they can just run along on their way with temporary custody of your children. In your case, they never even bothered to get the temporary custody, so they've already had your children possibly for over their legal limit of time. They've already had your children for 1.5 years under an interim order, and that leaves them open to getting a temporary order for 6 months, extending it for 6 months, getting another temporary order for 6 months, and extending that for 6 months, which means 2 years on top of what they've already got. And that is not the way it is supposed to be. The interim order should have been taken care of a long time ago. Your kids have the right to have a relationship with you consistent to what it was before they were apprehended. And I've said that to you a couple of times today because that's important. Because if you lose that, then what do you have?
They've destroyed the family then. And our children have a right to grow up with each other and not be separated. And they've also been denied seeing extended family and friends. Their entire community that they came from, they don't have access to it.
And your children also, according to the CFCSA, have the right to maintain relationships with extended family according to what it was before they were apprehended. And you're not the first person I've ever heard say that extended family was being denied that right as well. So that's another thing that you need to do, is get into the courtroom and, make sure that you've got an application for custody going into the courts.
Yeah, no, I was wondering if you can have 2 applications going on at the same time that may possibly conflict with each other. For instance, if you're applying for custody to be returned to yourself through a child protection hearing or whatnot, can you also have another ongoing application for the children to be placed on an interim basis with extended family while the child protection hearing is ongoing?
In family court, there are 2 sets of regulations. One is the Family Relations Act, which I always refer to as the FRA, and one is the CFCSA, the Child and Family Community Service Act. The CFCSA applies to any court proceedings dealing with the ministry. The Family Relations Act is family court where the ministry isn't involved. And not only can you have applications going at both for both at any given time, you can even combine court dates to include both, but it is usually not in your best interest to do so.
Okay.
Because a lot of the times the ministry will try to combine the FRA application with their court hearings, but from what I've seen, the ministry usually then gets all of their their witnesses on the stand and their social workers talking, and brings out all their allegations and everything that they want to say, and it destroys it for your family relations hearing, because then all this negative energy is brought to your Family Relations Act application as well.
Okay, so it's better to keep them apart.
I'm not saying it's better to keep them apart. I'm just saying that it always depends on the circumstances. In my experience and in many other people's experiences, it is not a good idea to let them, or you don't always have a choice, it is not a good idea to combine the applications on the same day. You can have both running through the courts, but I would try to keep them separate. For example, your mother can make an application for access under the Family Relations Act while you're going to court trying to fight the ministry's allegations and get the children returned to you. She can go ahead and try to do that. The ministry may show up and testify against her in her hearing. They may try to affect it. So they're just so that you know that possibility exists greatly. Mm-hmm. And even if they've closed their file, and in a lot of cases the ministry does just take kids away, close the file, and you've got what do you do then? You're not fighting the ministry to get your kids back. They close the file, they're out of the picture. And so you go to court and make an application for custody thinking, woohoo, they're out of the picture, and bang, there they are testifying against you. And it's the allegations that you never got to prove against yourself. So there's different situations, and sometimes you think, wow, it's great, they closed the file, or wow, it's great, I'm allowed to be supervised, my access is allowed to be supervised by a family member. It doesn't always work out to your best interest.